We appreciate everyone being here today. And Andrew's got some, this is Michael Johnson. Andrew's got some opening remarks here for us.
Hi, good morning, everyone. Thanks for joining us. Just as a reminder, Michael and I are both attorneys, but we might not be your attorney. So if you ask any questions today or any advice that we give today is general advice only. If you do have specific legal questions, as Dan mentioned up top, please submit them through our portal so that they can be protected by attorney-client privilege. It's going to be kind of a little different format than we normally use for these webinars today. Michael's going to be teeing off the slides, asking me some questions, and I'm going to be diving into more detail on each slide. And I'm going to let Michael take over and go through the agenda for us.
Thanks, Andy. Yeah, this is a hot topic right now. We get questions probably daily from our clients. So we figured now is a great time for a webinar to kind of bring everybody some general information, then also get you up to speed on some of the things that are happening right now with a new federal administration. So today we're going to talk about maybe a brief history of immigration law. We're going to talk about Form I-9 and what it is, how to use it. We'll be touching on E-Verify today as well. A big question that we get from clients lately has been, what if my business is approached for an audit or for some type of immigration raid? We're going to touch on that. And also, what sort of changes are going to be ahead with this issue of immigration? So I'm going to start off with our discussion here and just put the general question out there for Andrew. Why do we even have I-9s? Wasn't it always illegal to hire people that weren't authorized to work in the US? So what is this whole thing with the I-9?
Yeah, the whole issue of I-9s is, I mean, I guess in the history of our country, pretty recent. I'd have to take you back all the way back to the Reagan administration, the second Reagan administration. For those of you who were not alive at that time, think about Stranger Things, same time period. November 1986 is when the Immigration Reform and Control Act went into place. And it was kind of a reaction to something that's actually pretty similar happening nowadays. There was a lot of civil unrest in Central America. Those of you old enough might remember Iran-Contra, Oliver North. If you say I don't recall, bonus points for you. But there was a lot of political and domestic strife in Central America, especially, which led to in the really late 70s, early 80s, led to a lot of border crossings. People would flee their countries to come to America in hopes of a better place to live and to work and to escape the violence. Not too different from what we're seeing nowadays, at least my understanding of the driving impetus of illegal immigration. And the whole Immigration and Reform and Control Act is basically a three-legged stool. Number one, they said, all right, enough of these illegal immigrants coming across the border. We need some tougher border enforcement. And in order to do that, we need to put penalties on employers for hiring people that aren't supposed to work in the United States. And there was also a little bit of amnesty in there. So if you could prove that you were in the United States for a certain period of time before this November 6th, 1986 date when the law went into effect, you could sign up to a registry and you could provide information for that, and you could become work eligible underneath the Immigration Reform and Control Act of 1986. So what happened is, I think there led to like a couple million quote unquote illegal immigrants becoming registered and then becoming lawful to work in the United States as a result of this act. And so those are the basic three legs of the three-legged stool, so to speak, that the Immigration Reform and Control Act was based off of. Part of that, tougher border enforcement and sanctions for employers, they had to implement a way to figure out who actually was legal to work in the United States and who wasn't, and how employers would actually know that. And so, ta-da, Form I-9 became a thing. And so employers had to have Form I-9 filled out to enforce this new immigration laws. So what happened then is they also created, subsequent laws. It became, excuse me, illegal to fraudulently use identity documents or knowingly bring in, harbor, or transport unauthorized immigrants. This law also increased budget funding for the INS and Border Patrol. I don't know if INS exists anymore. I think it's been subsumed into the Department of Homeland Security. Um, and so immigration enforcement was stepped up, and uh, tough federal laws were put into place to make sure that no one was able to hire employees that were no longer able to work in, or not were no longer able, that were never actually ever able to work in the United States.
So Andrew, what exactly is an I-9 form?
All right, Form I-9 is, if you're an employer, if you're an HR person, you've seen it, you've filled it out probably numerous times. It's a form that must be completed so that employers can verify that all newly hired employees presented quote unquote facially valid documentation to verify that the employee's identity and their legal authorization to accept employment in the United States. So Form I-9, or the employee eligibility verification form, was provided as a way through the federal government to prove that employees were actually who they were and that they were legitimately able to work in the United States. It applies to all companies in the United States, even one individual. There are some very few certain exceptions, and I think we're going to talk about that in a couple slides. But basically, if you're an individual who's an employee who was hired on or before November 6th, 1986, and you're continuing in employment, you have to fill out Form I-9. So there are some exceptions, some casual domestic work in a private home, kind of like babysitters on a sporadic, irregular, intermittent basis. Unpaid volunteers and contractors are going to be exceptions. People who don't receive money for their work, I guess that would be a volunteer. Those are going to be the main exceptions that you're going to look for in terms of Form I-9. But if you're hiring an employee, I think the simple answer is just do Form I-9. It's there for you to help you comply with that federal law. Now, the question about who must complete it. It's going to be pretty straightforward. I'm going to give you a short answer, and it's going to be overly broad, and you're going to we'll have to dig into the weeds later. But who must complete it? Any single employer or employee needs to complete a Form I-9. It does not apply to independent contractors. Now, you might say, how do we determine who's an independent contractor and who's an employee? It's a great question because there's probably about 15 different tests out there depending on what state you live in. There's a test for unemployment, there's a test for workers' comp, there's a test for discrimination, and so on and so forth. And there's different tests at the federal level, there's different tests at the state level, because it needs to be extremely confusing so that us attorneys can keep our jobs. But the general rule of thumb I'm going to give you as to who is an independent contractor is that they're an individual or an entity that, one, has a contract to do a job according to their own means and methods. Two, supplies their own tools or materials. 3, offers those services to the general public. 4, works for a number of clients, a different number of clients at the same time. 5, has an opportunity for profit or loss as a result of labor or services provided. 6, and is going to invest in facilities to do all or part of their work. 7, is going to direct the order in which the work is to be done. 8, determines the hours during which the work is to be done. And finally, is subject to control only as to results, not how the work will be done. Now, pay attention to this because the Trump administration is probably going to make some tweaks to the independent contractor test. So just pay attention to that right now. We'll see what happens at the Department of Labor and at the EEOC. Those boards currently lack quorum. Same thing with NLRB, so there can be no rulemaking there. So it'll be interesting to see how that gets done, if at all, but that's something to keep an eye on as we traverse through the next almost 4 years. So one prime example that I've got for you guys is if you have temporary workers that you get through a staffing agency, those staffers that you get, those temp workers, are going to be employees of the staffing agency, not you. So those employees are going to have to fill out an I-9 with the staffing agency. You're not going to be responsible for them because the staffing agency is working as an independent contractor for you. Another example would be like if you hire out janitorial services for your office building or your suite or wherever you are. The person or the company that you hire to do that cleaning is likely going to be an independent contractor and would not be subject to Form I-9 requirements. I do know that some states have interesting laws. Minnesota, for one, has an independent contractor exemption certificate. So if you're in the construction trade in Minnesota, the Department of Labor and Industry in Minnesota, in order to be hired as an independent contractor, you have to get an ICEC from the state in order to show it to the general or whoever you're subcontracting from to prove that you actually are an independent contractor. That may be something that happens at the state level going forward. It may be something that happens at the federal level. But so far, this has tended to exist solely in more of the construction trades than it has in anywhere else in our workforce.
We talked a little bit about this, so we're going to move ahead to when must the I-9 be done?
Yeah, Form I-9 consists of a couple different sections, and Form I-9 has 2 main sections. Section 1 and Section 2. There's also a Section 3, which we're not going to really get into the weeds on today. That's re-verification and recertification. So Form I-9 must be completed. Section 1 has a different deadline than Section 2. So Section 1 should be completed at the time of hire. It should be completed no later than the first day of employment. So everyone's going to look at my Section 2 there and say, well, it says 3 days, but that's only for Section 2. A lot of employers are under the belief that Section 3, that the 3-day limit applies to all sections in the I-9, which is actually not true. So Section 1 has to be done at the time of hire. It can be done no later than the first day of employment. It can be done anytime after an offer is accepted. So if you submit an offer of employment to an person and they're going to start in a month and they accept it, they can complete Section 1 anytime before that first day if you want them to. One restriction on Section 1 is you can't have people fill out an I-9 pre-offer. That's just not acceptable under the federal laws. There are some weird rules for staffing agency employees. So if you add someone to your staffing agency pool, you can have them fill out Form I-9 even before they've received an offer of an assignment yet. But that's the exception rather than the rule. Section 1 is pretty straightforward stuff, though, so there's no reason that an employee really couldn't fill out Section 1, within the first 15 minutes of arriving on the job site. It's their first name, last name, pretty easy stuff. Social security number is optional unless you're an E-Verify user. I wouldn't be surprised to see if that gets some change. It's also optional for the employee to provide his or her email address or phone number. They have to say what their status is. Are they a citizen? Are they a lawful permanent resident? Et cetera, et cetera. And it's just real basic demographic information that every employee should know. And every employee does not need specific documentation like their passport or driver's license or social security number, EAD card or visa to fill out. So this is all pretty standard stuff that there's no reason it couldn't be done, right away on day one. Of note in Section 1, though, is that the employer is liable for all information provided on the I-9. So even though the employee fills out Section 1, the employer should review it after it's completed to make sure it looks complete. And if it's not complete, have the employee make some corrections or fill out the additional information at that time. On to Section 2. On Section 2, employees get to choose from a list of documents what documents they're going to provide to prove that what their identity is and to prove that they are legally authorized to work in the United States. So there's documents, there's lists provided by USCIS, and that list is there's list A, list B, and list C. Employees have the option of choosing one list A document or a combination of one list B and one list C document. I can tell you right now, an example of a list A document is your passport. Example of a list B document, I believe, is your driver's license, and list C would be your social security card. The employee generally must physically present these documents to whoever is filling out Section 2. Section 2 is then the person looks at the passport or driver's license and social security number card or whatever document the employee chooses to provide to fulfill the requirements of one list A or a combo of one list B and list C document. Of note, two things here. The person who fills out Section 2 doesn't have to be an employee of your company. It could be the employee's neighbor. It could be anybody, as long as you authorize them to act as an agent of your business. That's a lot of times is what happens with remote employees, excuse me, is that they're so far from the home office that having someone verify their documents is not really feasible. And there are also mobile services that will do that for a fee as well. So Section 2, all this stuff needs to be done within 3 business days of the date of employment begins. These documents need to be original documents. They can't be photocopies. But at the same time, you do not have to be an expert in fake documents or forgeries. I myself in college was a bouncer. So I was pretty good at spotting fake IDs, especially those kids from Minnesota who had the credit card ones who tried to use soldering irons to change the numbers on them. And those of my brethren from Wisconsin who would use X-Acto knives and splice numbers over the driver's license so that it looks like they were born in a different year. I was pretty good at that. You do not have to be. If it appears to be reasonably genuine, then you're good. And it's up to you to determine whether or not you think it's reasonably genuine or not. And the person who examines those documents should be the same person that signs under Section 2, again, within 3 business days of starting employment. Pretty simple stuff. And there's questions and I'm sure that people say, do we need to make copies of those documents that they present to list A, B, or C? And the answer is no. You do not have to make copies of those and keep those documents if you're just doing an I-9. We'll talk about E-Verify in the next slide. But if all you're doing is I-9 and you're not going through E-Verify, you do not have to make or keep copies of those documents. However, I should note that if you do make copies and keep them for your records, you need to do it for everybody. You can't just say, well, this guy looks fishy because, you know, he's got a Polish last name and maybe he's an illegal immigrant come over from Warsaw. No, you can't single out people because you think they might be suspicious and make copies of their documents. You do it for one, you do it for all. Uh, and then finally, at the bottom of that section 2, I think you fill in the employment date and sign a date form I-9, and voila, you are done.
You mentioned this, Andrew, but can you talk a little bit about E-Verify and then also any potential alternatives there might be to filling out an I-9 form?
Yeah, E-Verify is kind of fun. Um, it's free. Um, it's electronic. It is mandatory in some states. It is mandatory for federal contractors, and for everyone else, it's voluntary. Now, I say it's mostly electronic because, in the infinite wisdom of the federal government, if you're using plain regular Jane E-Verify, you still have to fill out Form I-9 and keep a copy of it. So it doesn't save you having to fill out the I-9 in paper form, and doesn't save you from having to keep a copy of the I-9. So it actually is kind of an additional step. But for those employers that use it voluntarily, it does provide some peace of mind that they know that the people that they hired have been vetted. And because what happens is uh, when you submit information into E-Verify, it checks information in the federal government systems to make sure that these IDs that have been presented actually match what they have on file. And so uh, you also need to keep copies of the identification documents along with the I-9, so that if there's ever a dispute or a question about what form was submitted into the E-Verify system, you have a record of it. And so um, that's E-Verify. Rather recently, I think it was announced originally in June of 23, but last October or so, the Biden administration announced the rollout of E-Verify Plus. Um, E-Verify Plus is an improvement upon E-Verify. All the other things that on this slide are still true. You know, it's free, it's electronic, it's only mandatory for some things, and is voluntary for everybody else. But what happens is the employee fills out an electronic I-9. And with that electronic I-9 and with the documentation that you take pictures of, those get stored directly in E-Verify Plus, and you don't have to keep a separate file of those documents. It basically offloads the duty and responsibility of having to maintain those records and those files, and it essentially pawns it off on the federal government, which they're the only ones that want it anyways. And of note, they're the only ones that can have it. I have had some clients come through and say, uh, our client wants a copy of I-9s from our employees to prove that they're legit. And the short answer is that never do that. It's a federal crime. The only entity that is allowed to view I-9s besides the employer is the federal government. You can get charged with crimes for sharing that, and you probably could face invasion of privacy lawsuits from your employees if you do that. So the short answer is never provide copies of I-9s except to the federal government upon request. And I think we're going to talk about the E-Verify process real quick.
Yeah, can you discuss that, Andrew? I know that that's an area that people always have questions on how it actually works.
Yeah, and it's a pretty slick process, in my opinion. Everything could always be better, and it could be automated. Maybe that will happen during this administration, maybe not. Maybe E-Verify Plus is going to be the answer to all the problems. But E-Verify is a pretty straightforward, simple system. And the process is not too different from the I-9. There's a couple extra steps because there has to be verification from the government that a person's identity or work authorization is actually valid. So it's real similar to start with Form I-9. Start with the same 1 day, 3 day deadline. Section 1 needs to be done within, the first business day of employment. Section 2 needs to be done within 3 business days. And that's still if you're doing regular E-Verify on paper. If you use E-Verify Plus, again, this is going to be done online. My understanding is that employees can use their phone, they can use a tablet, they can use any sort of electronic device to access and fill out the I-9 stuff for E-Verify Plus. But I don't know if I have a single client that's in E-Verify Plus right now, so I'm going to stick mostly with E-Verify. So you do your Form I-9. Additional step is you have to get the employee's social security number. And then you take that information from that paper I-9 and you basically play data entry and you submit that E-Verify case information from the I-9 and the social security number that you have into the system. The E-Verify system spits back an answer for you. Sometimes it's really super quick, like within seconds, and says, yep, everything's copacetic, verified. Um, and sometimes it doesn't. And so you need to retain the I-9. Sometimes you make data entry errors. Sometimes there's questions. Again, you need to keep copies of the authorization documents for E-Verify. So your list A or the list B and list C document. And you just pay attention to the E-Verify system to make sure they tell you if they need more information or if the person has been authorized to work. During that time, sometimes what the federal government says is we're not sure, and so we're going to give you a temporary non-confirmation. And a temporary non-confirmation is basically the federal government saying something's off, something's not matching here, and we can't give you the green light that this person is authorized to work in the United States right now. With that, they'll usually tell you what information they're looking for. Most of the time, it's a typo. A lot of times, my understanding is that it's an issue that Michael and you have come across with ACA is names, matronymic names and patronymic names not matching correctly, like with the ACA. And so, employers might put in the name incorrectly because of that. Based upon what the employee writes down and what the ID actually says. And once you wade through that process, ultimately the E-Verify system is going to give you, either an authorization from that TNC or it's going to give you a non-confirmation. And so that's the end of the road for you. Either they're verified to work or they're not. If they're not, you can no longer legally continue to employ them at your business, and you need to let them go. If they're verified, then everything's copacetic and we're all good.
One of the things we're getting quite a few questions on, and I wonder if you can speak to this, Andrew. We've heard a lot about more I-9 audits potentially occurring under the new administration. Can you tell everybody what an I-9 audit actually is?
Yeah. An I-9 audit is technically called an I-9 or an inspection. An inspection comes from ICE, and it generally starts with a letter in writing that says, hey, is a 3 business day heads up, and say, hey, we're going to be doing an I-9 inspection. Pull your records together. You got 3 business days to get it together. and um, we're going to be coming. We're going to look at these documents that you have, these I-9s. Um, you can waive that 3-day notice if you're the employer. I see absolutely no reason to waive that 3-day period. You want to make sure that you have all your ducks in a row, and you want to make sure that you have all the information that they want, so that the federal government spends as little time as possible at your premises. Uh, so this notice period, 3 days, and they'll give you parameters in that notice of intent, or notice of inspection, I mean, and they'll give you parameters of what they're looking for. Generally, they're going to be looking for all the I-9s that you have for current employees and for former employees within the time period that you are required to keep Form I-9. And you're, again, required to keep Form I-9 on file for 1 year after the employee's employment has ended, or 3 years from the date of hire, whichever is longer. So if they're employed for less than 1 year, you still have to keep it at least 3 years. If they're employed for more than 2 years, then you have to keep it a year after their termination. I-9 inspections are also going to request a list of your current employees. You can run a payroll report generally to satisfy that requirement with your HCM or HRIS system. Just a simple payroll report is going to work for that. And I think they're also going to ask in that list for a list of employees terminated, within the last 3 years, and employers hired within the last 3 years, so that you can, so that they can determine who actually has to have an I-9 on file that you needed to keep and who doesn't. It's important to note that unless you're an E-Verify participant, you do not have to show them copies of documents that you have regarding the list A, B, or C document, unless you actually kept them. So if they come in and say, let me audit your I-9s, and also, by the way, where's the copies of your documents, employee authorization documents and identity documents, you can say, I'm not required to give those. And that's pretty much it. I mean, it's a paper audit for I-9s. It's not the end of the world, and as long as you have all this information readily available, it should be relatively painless.
Along the same lines, looking at the I-9 inspections, I've heard a lot about people being concerned about potential raids by ICE at their business. What is that talk all about?
Yeah, so ICE enforces immigration law at the federal level, and immigration law generally is civil law at the federal level. There can be some immigration crimes, but generally they're all civil actions. And the main difference between I-9 inspections and ICE raids is that ICE raids are carried out by law enforcement agents through ICE. Sometimes they can deputize state or local law enforcement as well, but state and local law enforcement can't enforce them by themselves. They have to be supervised by a federal agent. And so it'd be interesting to see what happens, because I believe one of the executive orders that was issued on one of the first day or two of the new administration was that federal or state and local law enforcement was deputized to help out with ICE for immigration enforcement. I think we'll probably see some lawsuits about that if some sheriff comes into a work site without federal agency oversight. Probably get thrown out, my guess, for being an improperly executed warrant. But that's all legal dork stuff that I'm excited about. So ICE warrants, just like a warrant you might see on, Law and Order, or if you watch The Wire, they come with all the cops and they knock on your door and they show you a piece of paper and they say, we're here for X, Y, and Z. Um, what those ICE raids do is they rely a lot on intimidation. They expect people to kind of bowl over and just listen to what they ask, because they rely on the element of surprise, and they rely on overwhelming um, the employer essentially at the work site. So ICE raids do have limits. They're supposed to have a warrant. It might be an arrest warrant. If they have an arrest warrant for a certain individual, that warrant's going to detail where they can go to find that individual or not. If it's just a plain Jane arrest warrant and the warrant doesn't give them access to non-public areas of your work site, you do not have to let them back into, let's say, your factory or your back office that normal people can't get into. Now, sometimes the warrant will say that, hey, the warrant authorizes us to access, I'm going to use the generic phrase, non-public areas, to find this individual who is suspected of crimes or immigration issues or whatnot. And in those cases, they can go through non-public areas. The goal here, though, is if this were to happen to you, is to, if they have a warrant, ask to see the warrant, read the warrant. Warrants are pretty straightforward. I used to be a prosecutor. I used to apply for warrants for law enforcement all the time. They're not crazy technical. You can get them over the phone. It's pretty interesting how that works, but they state generally in plain English what they're looking for and where they can go and who can do it. So you're going to see probably an increase of these Blackies warrants, these civil search warrants, to enforce civil immigration laws. And I think that depending on how much funding they have, they're probably going to go after larger entities or entities in which they are fairly certain that there is a large amount of undocumented or unauthorized workers present. So I don't think they're going to be busting into Starbucks, to hire to arrest illegal immigrants. Maybe if they have a record that there's one person there, I don't think you're going to see a whole SWAT team go in there. But I think you're going to see these more on scale of larger operations, or where they have the actual evidence that there are things actually already going down. Because in order to get a warrant, you need to have proof to the judge that something, probable cause that there is a crime being committed, and that crime is something that can be remedied by the warrant.
On the next couple slides, Andrew, can you talk about, I mean, this is a pretty serious topic. This is serious stuff for employers. It's a real concern. Can you talk about some points on the next couple slides that employers can look at to help avoid an issue with this type of situation?
Yeah, absolutely. The first thing you need to do as an employer is you need to be proactive. Don't take this lying back or sitting down. Take this seriously. Take the time that you have before somebody comes, or before you get a notice of inspection, to do an internal audit on your I-9s. Make sure that A, you can pull all your I-9s that you need. B, that you have any I-9s that if you're missing some, recreate them, get them done. Now, if you're missing them and the employee is no longer there, document that what steps you made to try to remedy that. If you see somebody forgot to sign a section, there are absolutely rules handed down by DHS on how to handle those types of mistakes. There are rules on how to fix errors on your I-9s. If you're a client, let us know. We can help you with that. It's pretty straightforward in terms of how to fix I-9 errors. And make sure that you probably have gone through all of them, or at least the sampling of them. I'm saying if you have 2,000 employees, you don't have to go through all of them, but just do a quick, simple audit if you can to say, all right, I'm going to take 15 or 20 of these and do some spot checks to make sure section 1 is filled out and section 2 is filled out and that we're good and that nobody has overstayed their authorization date for their documents if they're not a U.S. citizen or permanent resident. The second thing you can do is you can be ready. Be ready for when they come. And by being ready, I'm saying understanding all the stuff that I talked about, making sure that you know what will be required and that you have a plan to get your documents together. And it probably makes sense to have somebody in charge of that, HR director, HR manager, in-house counsel, somebody that's ready if there is an audit notice or if there is an ICE raid that can act as point person for the company to handle that for your company.
Excellent. And can you kind of give us some thoughts on what else is gonna be happening under the new administration with immigration rules? Any thoughts on that? What's coming up?
Yeah, I do think that there are plenty of things down the road. I think the easiest thing for the new administration to do would be to institute E-Verify nationally. If they're super concerned about illegal immigrants and want to disincentivize illegal immigrants from coming and or staying in the country, the best way to do it, in my opinion, is to make sure that everybody's records match up with the federal government's records when they apply for a job. And the best way to do that is through E-Verify. Is it coming? I don't know. They've talked about it. They talked about it last time. It hasn't happened. I think it makes sense to do it if that's the goal of the administration. I do wonder what would happen if a large chunk of the workforce ended up being ineligible to work. But those are questions above my pay grade, and I'm not an economist, so I couldn't tell you what's going to happen. There has been talk similar to, if you remember my first slide about the three-legged stool and the amnesty of an online registry for illegal immigrants here, mostly DACA children who are not documented, and to give them some sort of amnesty, potentially with the providing of certain information and documents and whatnot. I haven't heard too much about that, but I expect that to happen in some capacity. Travel bans. I think if you remember the first Trump administration, right away off the bat, we got the Muslim travel bans. I think we're going to see something like that this time through. What exactly, I don't know, but I think used kind of like a tool like the tariff threats is travel ban threats to get countries or places to capitulate to demands as part of a negotiation ploy. So I would see travel bans potentially. So if you have employees from overseas that have to come over, or employees that live here and might go back home to visit and then return, this is just something to keep an eye on in case it does come down, so that you can come up with a plan in case something happens. Two big things that I saved for the end is the removal of temporary protected statuses. So you may have heard already that DHS revoked TPS status for Venezuelans who received it in 2023. At the end of the last administration, the Biden administration extended their TPS even longer. It's supposed to be up in this year. I think it was supposed to go in through September 21st.
Sounds like we might have lost Andrew for a moment there with his audio, but what he was going to say is that with the removal of the temporary protected status, that can put an employer in sort of a unique position. Number one, you may not know that somebody has lost their TPS. You may have hired somebody, their documents were in good shape. Everything looked fine as far as you knew. You were hiring somebody legally at that time. With the rescission of the temporary protected status, what that could mean is that if somebody had a green card and employment authorization document, that may expire and they may not be able to provide that document to you for renewal purposes. That could be something that could happen. The other issue could be that if you're an employer and you get caught with that, you may not know that. For example, again, with an EAD, it has information on it regarding somebody's country of birth, but it doesn't say which country they actually came from when they came into the country. So you may have an employee, again, using the Venezuela example, you may have somebody that's from there, they were on
Supposed
temporary
to end.
protected status. Oh, there's Andrew.
I'm sorry, was that?
You dropped out for a couple minutes there and now you're back.
Oh, okay.
And I was just
Uh,
discussing TPS with an example of Venezuela, as you had mentioned.
yeah. So TPS, I don't know if you guys got that, is going to be, has been revoked. People that have been here through September, or have been authorized to be under temporary protected status until September are going to lose it now in April. And employers that have hired employees with these EADs, which is an employment authorization document that they got through their TPS, uh, they're going to they're no longer going to be able to work after April of 2025 because of the revocation of that temporary protected status. And the last thing is CNHV parole, which is the parole program for Cuban, Haitian, Nicaraguan, and Venezuelan immigrants. This started under the Biden administration, and immediately upon Trump arriving in office, the program stopped accepting new applications for 2-year grants of parole. But there are still hundreds of thousands of people with these parole grants in the United States and living here legally. And so the question is going to be what happens to the parole program now that the program has ended, and what's going to happen to them in terms of immigration law going forward. With that, that's all I have for today. Michael, Dan, you got anything to add?
Yeah, just as you can see here, everybody, if you're not already one of our clients, we've just got some information on how to contact us. We can help you with all of the issues discussed today, in addition to anything else related to employment law, your human resources functions. You've got questions on hiring, I-9s, internal audits, raids, things along those lines. We certainly are teed up to help you with that. If you're one of our clients, this is a way that you can contact us if you're interested in becoming one of our clients and you've listened in today. And of course, one of our favorite things to say is, remember, compliance is not optional. It is mandatory, and we can help you with that